1102. You're charged with the second-degree felony offense of sexual assault from March 7th of 2018. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1103, you're also charged with the second-degree felony offense of sexual assault from June 9th of 2019. Again, that carries the same punishment range if you are found guilty, between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1104,
He's actually charged in 04 and 05 with aggravated sexual assault.
I haven't said those yet.
I understand. I think we checked off.
I did it right on the tablet. I was letting you know.
So in cause 25 DCCR 1104, you're charged with a first-degree felony offense of aggravated sexual assault from March 23rd of 2020. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? And then finally, in cause number 25 DCCR 1105, you're also charged with aggravated sexual assault. And this is from September 26th of 2024. Again, what that means is if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? I have here on the tablet plea bargain rejections in each of those cases that show that you've signed on with Mr. Rojas, that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for you to plead guilty on the, it looks like the aggravated sexual assault cases for 15-year term in the institutional division, to run concurrently on each of those aggravated sexual assault cases, so 15 and 15 that would run at the same time, with dismissals in the 2 sexual assault cases. You have every right to reject that and have a jury decide what to do in all 4 of your cases. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have all of your cases set for trial?
Yes, ma'am.
All right, we'll get that done. I do want to make sure you understand, Mr. Gibson, that after today, I will not accept this plea agreement unless there is new evidence that's received by the district attorney or your attorney between now and when we go to trial. If you want to change your mind and enter a plea of guilty, it would be to something different than this, or it would just be open to the court. Do you understand?
Yes, ma'am.
All right, and so Mr. Gibson, Mr. Rojas has been appointed to represent you. He's one of the attorneys that handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you are released, and Mr. Gibson will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. First, with a second-degree felony offense of aggravated assault with a deadly weapon from July 9th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Welcome is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. There is a finding of a deadly weapon in that case. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I need the I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker, okay? Good luck to you, sir. You can go back with the bailiff. I'm going to reset your sentencing, and I'm going to have a doctor come out and visit with you. They might do it online on that phone system, or they might come out. You need to cooperate with that. I just want to make sure what all's going on with you and what we need to go forward if I'm going to accept this plea of a probation. It's also very important that you quit acting like you're acting in jail. Do you know what I'm talking about?
Yes, ma'am.
You do, don't you?
Yes, ma'am.
All the things you've been doing, I have pages and pages of incident reports on how you're behaving in our jail. And I understand that you might have some issues with some behavior stuff and some things that we're going to hopefully get taken care of when you get out, if you get out. But you have got to quit treating the correctional officers disrespectfully. You've got to quit calling names. You quit talking like you're talking out there. Because if you don't, I don't have to accept this plea agreement and give you a probation. Do you understand?
Yes, ma'am.
So just lay low, do whatever time you got to do out there until we get you back, talk to the doctor, and then we'll see where we are when you get back. All right? Go back with the bailiff. Good morning. You're Deandre Willis. This is 25 DCCR 1048. And Mr. Willis, you're charged with the offense of burglary of a habitation, a second-degree felony from June 26th of 2025. And what is the announcement?
Your Honor, the complainant is Mr. Willis's girlfriend. I believe she signed a non-prosecution affidavit.
Okay, Ms.
She
Martinez.
did, Judge. The offense involves a firearm that was stolen, which is what gives me some concern. I do have the non-prosecution affidavit. I'm not inclined to honor it without her presence here in court, which we have requested, but she's obviously not here unless we'd like to do a bailiff's call
If you'll,
outside.
yeah, we can call her name at
Colette
least.
Richards.
Colette Richards, please.
In the alternative, Your Honor, if I may just have a week or two to issue her a subpoena, if she wants to proceed with the dismissal in this case, I'd like her to explain to the court why I document the record. Or even next Monday, if you'd allow.
Well, or Tuesday, we can do Tuesday. I just want to make sure is that enough time for you? Okay, because I know after that,
I'll send it out.
we're down
I'll send it out right after document.
for a week. All right, thank you. So what I'll do is I'm going to reset it just 1 week for the state to reach out, send a subpoena if they can, and get her here, and then we'll go forward next week on Tuesday. You go back with the bailiff. Robert Lowe?
Yes, ma'am.
Give me just a second here. I signed those but didn't fill in the date, if you could for me, please. And Ms. Holmes, will your client waive the formal reading of the indictment in each case?
He will, Your Honor. Sorry.
It's been
One of those
it's been a long day already.
And Judge, if we may, we're going to proceed on 3. I
Yes, ma'am.
collected in the paperwork, subject to the PSI. I know cases are always subject to your
Sure.
discretion after the PSI, but just due to the nature of it, that's why I included that.
Yes, ma'am, thank you. All right, Mr. Lowe, in cause number 19-32660, you're charged with the third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And then in cause number 19-32661, you're also charged with a third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
And then finally, in cause number 19-32662, you're also charged with a third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreements that you've reached on these 3 cases, that it would be a 7-year deferred probation in each of those cases. There would be a $1,000 fine. You would be required to register as a sex offender, subject to the PSI, it says, and I guess any other conditions that I felt like were necessary to place on you. That as a condition of this agreement, if I follow it, the state would also dismiss cause numbers 19-32663, 32664, and 32665. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Mr. Lowe is not competent?
No, Your Honor.
All right, sir, in each of these cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will come back at a later date for sentencing. Just based on the nature of the offenses and what the agreement is, I'm not going to do anything to modify the bond at this time. We'll just get that pre-sentence report done, and then we'll see where we are when we come back.
It was at large for almost 5 years, so I think it's probably better to keep it.
Okay, sounds good. You can go back with the bailiff.
I have a question.
Yeah.
How long would I have to register?
That'll be a question between you and your attorney. We'll go over that at sentencing. It might even show on that,
I'll look at it.
on the pad, that probably needs to be signed at this point. I mean, these are registrable offenses, correct?
Yes.
Yeah, y'all need to go ahead and
Do it
sign
now?
the sex offender
Okay.
registration while you're here today. That makes it easier, and you can go over that with them. So I do want to make sure you understand, as part of all of these agreements and pleas, that you will be required to register as a sex offender. How long and all of that, you can go over with Ms. Holmes. Y'all are going to sign another document today that shows that you have gone over that and that you understand you will be required to register as a sex offender. Okay. And lifetime? All right, so lifetime registration.
Okay.
All right, thank you. Mr. Thomas, in cause number 25 DCCR 1151, you're charged with the state jail felony offense of theft of property with previous convictions from June 11th of 2025. The indictment alleges you were previously convicted of theft July 17th of 2023, and then again April 10th of 2025. It further alleges that you were convicted of possession of a controlled substance, a state jail felony, April 25th of 2013, and after that was final, you were convicted of forgery of a financial instrument, a state jail felony, September 11th of 2015. And how do you plead to that charge?
Guilty.
And are those prior convictions all true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily? And because you've actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, Mr. Thomas, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions, find those 2 prior convictions true, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Yes, we put a notation, that the state will not pursue. There's possibly an additional charge, from that night. It was a
Yes.
prohibited item in a.
Yes, I saw that, and that's part of that agreement, correct, Mr. Coleman?
Yes, Judge, the unfiled possession of a prohibited item in a correctional facility.
Okay, thank you, Mr. Coleman. All right, you can go back with the bailiff. With the first-degree felony offense of aggravated robbery, and Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at,
I think 600,000.
okay, and Ms. Malfino, you have a witness. Do you want Ms. Malfino to go first? Would you rather go first, or
No, I'm first, you can go.
go ahead, Ms. Malfino?
Okay, Judge, just for purposes of the record, I would tender to the court, just for ease of use, State's Exhibit Number 1, which is a probable cause affidavit in this case, and I will call Detective Kane.
Any it's in my file. Do you any
Right.
objection
No
to,
objection.
States 1 is admitted for purposes of this, hearing. Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead.
Could you please state your name for the record,
Dwight Dean,
and how are you employed?
Beaumont Police,
How long have you been in the city of Beaumont?
31 years.
You're a certified peace officer in the state of Texas.
Yes, ma'am.
And you and I discussed this case involving Hakeem Thomas as well as his co-defendant Tyree Hartley last week. And we're here in order to address the bond in this case. Can you briefly go over your involvement in the case and your familiarity with the facts in this case and why you think it's important that this defendant remains in custody?
My involvement is through Southeast Texas Outfit Task Force. We deal with auto burglaries, and a new offense was added to our penal code called jugging. We believe that this offense started out as a possible jugging on breaking into a car, and which ended up into injury with two of the guys involved. One standing here as well. That ended up injuring an infant child during, through coordinated efforts of us locally here in Beaumont, myself, officers on the street, along with deputies of the Chambers County Sheriff's Department. We're all involved to have these guys arrested.
So they did actually flee from this jurisdiction into Chambers County after this offense, which again involved an infant child in the back seat of that car being injured when they attempted to break into that car and retrieve the money that the child's mother had obtained from the ATM.
That's correct. The ATM of the bank, that the vehicle, the dad left the vehicle, and the mother and the infant child were in the back seat of the car. Not only did they break into the car with shattering glass on top of the baby and the mother in the car, with her continued efforts during the crime itself, they didn't stop. They kept on once they were successful, if you could say that, any kind of theft, they did flee from here and were actually located, found in the same vehicle.
And did you subsequently with Detective Andrew learn that both of these defendants in this case had committed similar types of acts in various jurisdictions across Southeast Texas, Harris County, Fort Bend County, Austin, et cetera?
Yes, ma'am. Some of it did happen that actual day, and then, of course, some of it was put together, shredded in the background, and those are after the arrest.
And is it your position, based on all of your years of training and experience as an officer here in Jefferson County, Texas, that to maintain the security and well-being of the safety of the citizens of Jefferson County, that it be best that pending prosecution of this offense, this defendant at least remain with some kind of a high bond from this court?
Yes, ma'am.
Thank you. I'll pass the witness, Judge.
Thank you, Mr. Lewis.
Yes, just briefly. Now, you said you were definitely part of the investigation of this allegation, correct?
That's correct.
Now, during your investigation, was it ever shown that a weapon or any deadly weapon anything was exhibited to the plaintiff witness or anything? So there was no weapon involved as far as we know?
Not that I'm aware of.
Okay. And as far as your investigation as it relates to my client, was it any statements or evidence that showed that he was involved with the actual breaking of that of the glass or possibly injuring the child involved?
Not that I'm aware of.
Is there any evidence that would show that they even knew it was an infant child in the car at the time?
No, it's not.
Okay. I'll pass the witness, Judge.
I've done further, Judge, just argument.
Thank you. Thank you, Officer Dean. Any witnesses, would you wish to call your
No.
client with regard to his financial status? Mr. Thomas, come back around. Best you can, raise your right hand. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Mr. Thomas, as far as your financial situation, you're currently in custody, correct?
Yes, ma'am. Yes, sir.
Now, do you have any money saved up that could be used for your bond?
No, sir.
Do you have any property that could be sold or vehicles or anything of that nature that could be sold in order for your family to come up with your bond?
No, sir.
Who would be responsible in trying to come up with the bond amount for you?
My mother and my wife.
Your mother and your wife? Have they been in touch with any bondsmen
Yes,
currently? Okay. And from the information you received, how much of a bond or commitment they will be able to make to try to bond you out?
The complete bond amount, between $70,000 and $100,000.
Between $70,000 and $100,000. Okay. Now, were you employed before you came into custody?
No, sir.
Do you have any employment or anything available to you if you're able to make bonds?
Yes, sir.
And what would that be?
Being a helper to my wife's father with his CDL truck.
Okay. And that will give you enough money to be able to take care of any pretrial conditions or anything you need to do with
Yes,
your,
sir.
your representation in this case?
Yes, sir.
Okay. I pass the witness in regards to.
Ms. Malfino.
Mr. Thomas, tell the judge a little bit about your criminal history, starting when you were a juvenile.
I have no juvenile record.
Were you in trouble as a juvenile over in Harris County?
No.
What about your theft, your state jail felony theft from a person, which is basically another way of saying,
That's
who
not
did you
juvenile,
rob?
no.
Don't talk over, okay?
I'll
Just
talk
wait
to
till
you.
she's finished
Yes,
talking
ma'am.
so the court reporter can take one at a time.
Yes, ma'am.
Where was that?
Go ahead, Ms. Malfino, you might want to read.
Your theft from a person, which is basically a robbery, where was that?
2021,
Where, in Harris County?
Rosenberg.
Have you been in trouble in San Antonio?
No, ma'am.
Have you been in trouble in Austin?
I have a pending case in Austin right now
For what?
for a robbery.
Do you have any kids?
Yes, ma'am.
someone would have done this to your wife and your baby would have been in the car, what do you think that person should get? Prison time?
I don't understand this.
I don't have anything for you, Judge.
All right, anything else?
Nothing else for this witness, Judge.
All right, you may make argument.
Judge, as far as this case goes, you've seen it, it is charged as aggravated robbery, but it's one where we don't have a deadly weapon involved or anything like that. The biggest issue, I think, with this situation, of course, is my client does have some criminal history and lives out of county. I believe there's already some bond conditions in place for him to have the GPS monitored and be able to go to be in Harris County, come back, of course, for court and everything. We are asking for a bond in between $75,000 and $100,000. I think that, including with the GPS monitoring and everything, would be enough to cover, one, secure his return to court, and also, of course, satisfy any public safety concerns while these cases are pending. He does not have a hold for the case in Austin, because I believe he's still on bond for that situation.
I find out while I'm being custody.
Right. So he is on bond for that, so he will be allowed to be released. My understanding, there's not been a court date set up there. We don't anticipate that interfering with us here as far as any type of issues. And from
When did you make bond on that case?
July, sometime in July.
Okay,
I'm not sure the exact date.
Okay, that's
sometime
fine.
in July.
all right, go ahead.
But from talking with his family, they have been involved with this case he has going on up in Austin, and that, I think that actually will be resolved pretty quickly, and won't interfere with what we have going on here.
What, if anything, and Officer Dean may know about, I know you noted some other counties where there were some potential cases or issues. Do you have any other information on those?
I have reached out to Fort Bend, Judge. I have had difficulty in getting a final answer. A charge looks very looming. How they initially filed them, I think one of the impediments that I'm up against is in Harris County, Fort Bend County, that surrounding area. They have dropped a lot of stuff down to some very low amounts of time. So it looks like if an initial charge comes in as an aggravated robbery, it ends up 6 months later as theft from a person in the state jail. So that's really the totality that I've been able to.
Do you have any other
obtain from
additional
the
information?
co-defendant.
No, ma'am, that's exactly what I was gonna say. It looks like there's been some initial charges that were actual aggravated charges that were bumped down.
Okay.
And I would also ask if the court would take judicial notice of his incident of behavior report.
I will. I also have, and I think you guys should have received 7 pages of incident reports from the jail as well, which obviously y'all know my thoughts on that. And so anything else?
No, Judge, and the state does not object relief necessarily in this case, just not, I would ask that it remain in an amount at least above $350,000.
And Judge, if I may, to the jail incident reports, I think those were like early on when he got into custody. Of course, Mr. Thomas did speak about those and how, of course, he should conduct himself out there, and I don't think that he has had any other issues since that conversation.
I guess my concern, and I understand from the probable cause that the allegation is that Mr. Thomas was the driver of the car, but I don't know that that makes it any better whatsoever, because it doesn't sound like there's any evidence on why he and Mr. Hartley were in Jefferson County, if they're from Harris County and that's where he's gonna live, why they're in Austin, why they're wherever they are, other than to come into our county and break into people's cars or jug, which has become a huge issue. And so based on the evidence today with regard to this specific offense, based on the jail incident reports, based on the information received through, again, take judicial notice of the court's file, the magistration information as well, the fact that there is at least one pending case that is similar, others that sound similar, just with some different outcomes. I don't think it is in anyone's best interest that Mr. Thomas have any relief today, and so I'm going to deny the motion to reduce the bond. We will reset the case and for an announcement and see where we get. All right, thank you, sir, for being here, Mr. Kane, Officer Kane. All right, do I have a offensive burglary of a building? And that's from July 5th of 2025, and how do you plead to that charge?
I do plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, I do.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated for 5 years. There would be a $500 fine as well as $4,010 in restitution, and that you would be ordered not to go onto the premises of bicycle sports and follow all of the other rules and conditions of probation. Is that your understanding?
It is my understanding, Your Honor.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Josie's not competent?
No, Your Honor.
With regard to waiving pre-sentence report, is there a criminal history?
Judge, it's minimal. I just show a previous misdemeanor conviction for burglary of a vehicle and another misdemeanor conviction for possession of a controlled substance. That's all.
Any objections, since we know that restitution amount, to waiving that?
Oh, no objection, Judge.
No objection from the defense, Your Honor.
All right, Mr. Josie, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, I'm going to waive the pre-sentence report, find you guilty of the state jail felony offense of burglary of a building, follow the agreement that you made with the district attorney, sentence you to 2 years in the state jail prison, but I'm going to probate that, and you'll be on probation for 5 years. You are ordered to pay the $500 fine. You're ordered to pay the $4,010 in restitution and to follow all of the other rules and conditions of probation, including not being on the premises of bicycle sports. If you do everything you're supposed to on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that is if you violate any condition of probation, you can be brought back into court and you would be looking at that 2-year sentence that you've already agreed to. Do you understand?
I do.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Excuse me, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Wilkerson. Now, $4,010 is a lot of money to pay back. 5 years might seem like a long time, but it's not. It's very important to me that you start making payments on that immediately. And I do want that paid before the fine for probation. And so what can happen is a lot of people think, well, I'll wait for my tax refund, or I'll, sell this later and pay. It doesn't work that way. You need to make payments, even if they're small, every single month, because that'll all add up.
Yes,
What can happen is you can do everything else right on your probation. And at the end of your probation period, if you haven't paid that back, and I find that you could have paid it back, you could still then get revoked and go to prison for 2 years. You understand?
yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff.
Thank you. I will perform due diligence.
Thank you, sir.